in the Chancery Court of Lafayette County, Mississippi, Robyn Tannehill and J. Ray Tannehill versus Matthew Reardon. This is a motion to dissolve the permanent restraining order. Comes now your respondent, Matthew Oliver Reardon, whom hereby files with this court his motion to dissolve the permanent restraining order and seeking to dissolve the permanent restraining order granted to the petitioners in June of 2017. In support of his motion, respondent offers forth the following set of facts and reasons this court should schedule a hearing and dissolve the order entered. Number 1. On June 6, 2017, Robyn Tannehill was elected mayor of the city of Oxford, Mississippi. Number 2. On that same day, respondent was scheduled on the city minutes to address the Oxford Board of Aldermen, the mayor, and community at the Oxford City Hall Board of Aldermen meeting about what respondent considered to be a serious grievance within the city that he saw setting a bad precedence. Board minutes for June 6, 2017 is attached hereto as Exhibit A. Number 3. That on May 22, 2017, petitioners petitioned this court for an emergency temporary restraining order and permanent restraining order, which was promptly served on the respondent. Petition is attached hereto as Exhibit B. Number 4. That the temporary restraining order was improperly and immorally petitioned for at that time to effectively block and silence the respondent from addressing City Hall as scheduled. Number 5. The permanent restraining order was signed under duress on June 15, 2017, just 9 days after Tannehill was elected mayor, while the petitioner sat incarcerated in an orange jumpsuit under the false pretense that the issue respondent was incarcerated for at that time would go away and that he would regain his freedom if he simply agreed to the permanent restraining order without contesting it at the scheduled hearing. Order is attached as Exhibit C. Number 6. However, none of that which was promised to the respondent actually occurred, and as a result of everything, the permanent restraining order should be considered void and dissolved. Number 7. In no other circumstance would respondent have consented to a permanent restraining order based upon what was listed in the petition. Respondent took the bad advice under immense stress from an attorney whom wasn't even retained to represent him in Chancery Court for this matter, as he was solely retained for Circuit Court. Number 8. No threat of bodily injury was ever made to the petitioners by the respondent, and the claims listed by the petitioners were overstated, opinionated, and misconstrued. Number 9. The permanent restraining order entered by this court is oppressive and should be considered unlawful and unconstitutional, as it now directly infringes on the respondent's First Amendment right. Due to the broadness of this order, respondent is effectively barred from Oxford City Hall, a key building for the respondent to petition the local government for a redress of grievances within the city limits of Oxford, Mississippi, to include open access to public records requests pursuant to the Public Records Act and the Freedom of Information Act. As such, respondent stands ready to fully challenge any denial of dissolution through any and all available channels. Number 10. When an application alleges sufficient facts to support a contention that the petitioner's sentence or judgment is void or subject to collateral attack, an evidentiary hearing must be held if the facts are in dispute and if he did not receive a full and fair evidentiary hearing in the state court on the point raised, either at the time of the trial or in a collateral proceeding. Townsend v. Sane. In other words, a federal evidentiary hearing is required unless the state court trier of fact has, after a full hearing, reliably found the relevant facts. Number 11. The fact that this matter now involves the deprivation of a federally protected constitutional right guaranteed under the First Amendment, and the fact that respondent has not received a fair trial by the state trier of fact, makes the jurisdiction of this court improper in the Chancery Court, and thus must be removed to district court, if not dissolved. Wherefore, all premises considered. Respondent seeks to have the original permanent restraining order fully dissolved, based upon its merits, application, and any other reason listed out in this motion. Else, respondent seeks to have this matter removed to the United States District Court for a federal evidentiary hearing to be held and for a ruling on its constitutionality to be made regarding the deprivation of rights detailed out. Respondent prays for any other relief, special or general, for which he may be entitled for having to bring this motion. Respectfully submitted this 23rd day of June 2022. Matthew Reardon,